Ian Dobinson is a senior lecturer in the Faculty of Law at the University of Technology, Sydney. His area of expertise is the criminal law, working particularly on a topic we're here to speak about today, drugs and drug use. Ian, let's start by hearing about the case of Burns.
The case of Burns' recent High Court decision has significantly made it clear that those who supply drugs to others who then self-administer those drugs, that is only going to be in very special and specific circumstances that such drug suppliers will be criminally liable.
This reminds me of another case, of course, which is the case of Suresh Nair, which some people might know about, which is a young Sydney neurosurgeon who I believe pled guilty to manslaughter in somewhat similar circumstances to that of the Burnses.
Well, they were similar in the sense of someone supplying drugs to the victim. In the case of Nair, who was a doctor, he had a serious cocaine habit and had got a large amount of cocaine. He had arranged for 2 escorts to come to his house for a party, in effect. He told one of them that she should just help herself to this very large amount of cocaine that he had on the coffee table. She took an incredibly large amount of cocaine and she started to convulse and overdose. Nair, who was a doctor, went out to simply get some Panadol or that sort of medication. And when he came back, the victim was near death and died very soon thereafter. So in that particular case, the reason for his liability, noting that he pleaded guilty, arguably was on the basis that he was a doctor and that therefore duty of care arose. But from a procedural perspective, Nair was originally charged with her murder on the basis of reckless indifference. So he was under pressure in this particular case to plead guilty to the lesser charge of manslaughter.
So both of these cases then involve supply of drugs in some kind of different circumstances. What are the options then? I mean, we've got one here of sort of a negligent manslaughter, and then what were the options for prosecutors in relation to the Burns' case?
In the Burns' case, there appears to be 2 options for the prosecution. The first and most straightforward is the accused or accused have actually administered the drugs to the victim. And it's well settled law that if that takes place, then the accused in those circumstances will be liable. The other option is negligent manslaughter, that in the circumstances the accused may have taken on a duty of care in relation to the victim and then likely failed in relation to seeking appropriate and timely medical attention, and this has then led to the death of the victim, and on that basis gross negligence can be determined.
So in relation to negligence then, I mean, as you said, it's about a duty of care. Clearly engaging in this kind of drug taking, either in the case of Nair or in the case of the Burnses, is a dangerous thing. What about the kind of sense that the victim here is a fully kind of informed, consenting adult?
This is the issue in terms of the High Court in Burns ultimately finding in favour of Mrs. Burns and acquitting her in relation to her conviction for manslaughter, largely because they determined that the victim in these circumstances had self-administered, had done so in a fully informed way as a consenting adult, and in those circumstances a duty of care did not arise in the drug supplier. And that the Burns decision is clearly telling us now that such a duty is only going to arise in quite specific circumstances. And in this regard, the High Court approved of an English decision called Evans, where the victim, who was 16 years old at the time, had been supplied drugs by her mother and her auntie. Her auntie is Evans in this particular case, and they failed, both of them, in relation to seeking medical assistance for the victim when she overdosed from the use of this heroin. Now, the circumstances in relation to the case of Evans, in relation to the auntie, so as to give rise to a sort of special relationship, was to do with her actually not just supplying the drugs, but also being the victim's auntie, and also the circumstances in which both the auntie and the mother were present at the time that, in effect, the victim, right, was overdosing and dying from the heroin.
So then, taking Evans and the High Court's decision in Burns, what's your sense of the direction of manslaughter charges based on drug supply and death?
In the circumstances of negligent manslaughter, that it's only going to arise in these very special and limited circumstances. Outside of that, liability for a supplier in relation to the drug supplier has actually administered the drugs to the victim. And this could arise in circumstances as in Cato, where the victim in Cato was just physically incapable of injecting himself with the drugs, and so the drug supplier injected Cato. Where that occurs, liability will arise. Outside of that, the Evans type situation, the Nair type situation, where he was a doctor, then it's really going to be limited to those sort of special circumstances. The High Court, I think, was quite clear in that they really weren't going to extend the notion of duty of care beyond the mere supplier. The other, I think, significant case to refer to here is the Mark Wilhelm and Diane Brimble case on the P&O cruise. And in these circumstances, again, Justice Howie was very clear early on in that case that Mark Wilhelm owed no duty of care to Diane Brimble.
Thank you, Ian, for your time.